So, good day, everyone. For today, we will be discussing the Agricultural Land Reform Code or the Republic Act 3844. My name is Jewell Algordo, and I will be discussing first what is the Agricultural Land Reform Code or the Republic Act 3844. In August 8, 1963, President Diosdado Macapagal signed a law called the Agricultural Land Reform Code or the Republic Act 3844. So before this, there was a previous law which farmers used to follow, the share tenancy law, which refers to how farmers had to give most of their crops to landlords, which was very unfair. So the new law, which is the Agricultural Land Reform Code or the Republic Act 3844, aimed to end this system, which is the share tenancy system. It gives lands to farmers and improve their lives and the economy in rural areas by making things fairer. Let us now proceed to the salient features or the main features of the Agricultural Land Reform Code. So the first one is the agricultural leasehold system, kung saan pinalitan nito ang lumang sistemang share tenancy or what I have mentioned earlier, kung saan nagbibigay ang mga magsasaka ng bahagi ng kanilang ani sa may-ari ng lupa. The second one is the rights of agricultural labor, kung saan kinikilala at pinoprotektahan ang mga karapatan ng mga manggagawang bukid. The third one is the authority to acquire and distribute land. Layunin nitong hatiin ang malalaking ari-arian at isulong ang pagmamay-ari ng lupa sa mga magsasaka. Fourth is the financial support for land acquisition o ang pagtulong sa mga magsasaka na makabili ng lupa na ipapamahagi ng gobyerno. Fifth, credit and assistance for agriculture o ang pagsuporta sa mga magsasaka sa pamamagitan ng mga pautang. Sixth is marketing and technical service. Seventh, unified administration for land reform. Eighth, land capability survey and registration. And the last one is judicial system for land disputes.
Abolition of agricultural share tenancy. So share tenancy is when a landowner allows a farmer to work on their land in exchange for a share of the harvest. For example, 60% for the owner, 40% to the farmer. This system was abolished because it was unfair. Farmers often stayed poor and dependent on landowners. The next one is establishment of agricultural leasehold relation. Instead of sharing harvest, the law says that the landowner and the farmer should have a leasehold relationship. The farmer rents the land and pays a fixed amount in money or produce, not a share of the harvest. This can be agreed in writing or verbally. The next is parties to agricultural leasehold. This relationship exists between the landowner and farmer. The landowner is the one legally owns or manages the land, and the farmer who personally cultivates the land. For example, a landlord and a farmer who plants rice both have a leasehold agreement, and only these two are parties to that agreement. The next one is tenure of agricultural leasehold relation, meaning once a farmer becomes a lessee or tenant, they have the right to continue farming the land as long as the lease exists. The landowner can't just remove them without legal cause.
Hey everyone, I am MARIANNE DULOT and I will be discussing how agricultural leasehold relation is extinguished. The agricultural leasehold relation shall be extinguished only by number one is abandonment of landholding without the knowledge of the agricultural leaseor. It means if the farmer leaves the land without telling the landowner. Number 2 is voluntary surrender of the landholding by the agricultural lessee, written notice of which shall be served 3 months in advance. It means if the farmer decides to give up their rights to the land, they must provide written notice 3 months in advance. Number 3 is absence of the persons under Section 9 to succeed to the lessee in the event of death or permanent incapacity of the lessee. It means if the farmer dies or becomes permanently incapable of farming and there is no one to take their place according to Section 9, the leasehold is extinguished. The death or incapacity of the parties. Agricultural leasehold relation shall not be extinguished in case of death or incapacity of the parties. It means the agricultural leasehold relation is not automatically ended if the farmer dies or becomes incapacitated. Lessee's right of preemption. In case the agricultural lessor decides to sell the landholding, the agricultural lessee shall have the preferential right to buy the same under reasonable terms and conditions. It means if the landowner decides to sell the land, the farmer has the first right to buy it under reasonable terms and conditions. This is to protect the farmer's livelihood and investment in the land.
Hello, I am CYBELLE G. PURA. So my topic is all about agricultural leasehold contracts. So basically, ito kung paano pinoprotektahan ang karapatan ng mga magsasaka sa lupang sinasaka nila. So ang una is leases right of redemption. Leases right of redemption in case the landholding is sold to a third person without the knowledge of the agricultural leases, the latter shall have the right to redeem the same at a reasonable price and consideration, provided that the entire landholding sold must be redeemed. So, unless is right of redemption, ito po siya yung kapag nabenta yung isang lupa sa iba na hindi alam ng magsasaka, so may karapatan po siya na tubusin o bilhin ulit ang lupa sa makatarungang presyo. Next is agricultural leasehold contract in general. The agricultural lessor and the agricultural leasee shall be free to enter into any kinds of term, conditions, or stipulations in a leasehold contract, as long as they are not contrary to law, morals, or public policy. So, the agricultural leasehold contract, both lessor and lease, ay pwedeng magkasundo sa terms ng kontrata basta hindi ito labag sa batas o public policy. Bawal yung mga kondisyon na sobrang taas ng renta o nagpapahirap sa magsasaka, tulad ng sapilitang pag-upa ng gamit mula sa lessor or paggawa ng walang bayad. Then, the form and registration of contract. Dapat nakasulat ang kontrata sa wikang naintindihan ng magsasaka at dapat permado o may tambak nila at ng lessor. Lastly is the registration of leasehold contract. Dito naman po ay ipafile na nila ito sa municipal treasurer para maging official at may record ng date, time at registration number. In short po, dito po sa aking mga na-discuss, ito po ay pinapakita kung paano binibigyan ng batas ng proteksyon at patas na karapatan ang mga magsasaka sa kanilang lupang sinasaka. Yun lang po. Maraming salamat.
From lien or execution, the following shall be exempted from lien execution against the agricultural lessee. Number 1 is 25% of the interproduce of the land under cultivation. It means that 25% of the crops grown on the leased land cannot be seized to pay off the farmer's debt. Number 2 is to manage and work on the land in a manner and method of cultivation and harvest which conforms to proven farm practices. Like it means work animals like carabaos and farm tools belonging to the farmer are protected as long as their total value does not exceed 1,000 pesos. Rights of agricultural leasing. Number 1 is to have possession and peaceful enjoyment of the land. It means the farmer has the right to possess and peacefully use the land. Number 2, to manage and work on the land in a manner and method of cultivation and harvest which conforms to proven farm practice. The farmer can manage and work the land using their preferred methods for cultivation and harvest as long as they follow proven farming practices. 3 is to mechanize all or any phase of his farm work. So, it means the farmer has the right to use machinery for any part of their farm work. Number 4 is to deal with millers and processors and attend to the issuance of credence and warehouse receipt for the produce due him. The farmer can deal directly with millers and processors for their harvest. They also have the right to handle the issuance and credence like receipt for good deposit in a warehouse and produce warehouse receipt for their producer. The agricultural lessee shall have the right to be indemnified for the cost and expenses incurred in the cultivation, planting or harvesting and other expenses incidental to the improvement of his crop in case he surrenders or abandons his landholding for just cause or is ejected therefrom. It means if the farmer gives up the land for a valid reason, just cause, or is forced off the land, they have the right to be compensated. Obligation of the lessee. Number 1 is to cultivate and take care of the farm, growing crops and other improvements on the landholding as a good father of a family and perform all the work therein accordance with proven farm practices. It means the farmer must cultivate and take care of the farm, crops and improvements as a responsible person would, following good farming practices. Number 2 is to inform the agricultural lessor within a reasonable time of any trespass committed by third person upon the farm, without prejudice to his direct actions against the trespasser. It means the farmer must inform the landowner promptly if someone trespasses on the farm. This doesn't prevent the farmer from taking direct action against the trespasser. Number 3 is to take reasonable care of the work, animals, and farm implements delivered to him by the agricultural lessor and see that they are not used for purposes other than those intended or used by another without the knowledge and consent of the agricultural lessor. It means if the landowner provides work, animals, and farm equipment, the farmer must take reasonable care of them. They cannot use them for unintended purposes or allow others to use them without the landowner's permission.
Good day, I'm Heidi BELTRAN and I'm going to discuss the three topics, namely termination of leasehold by agricultural lessee, rights of the agricultural lessor, and prohibition to the agricultural lessor. Now, I'm going to discuss the termination of leasehold by agricultural lessee. The agricultural lessee may terminate the leasehold during the agricultural year of the following causes. But first, what is leasehold? Leasehold is like you own the right to live in a property for many years but you don't own the land itself. Una, sinasabi dito kung ang may-ari ng lupa o sino makatawan sa kanya ay malupit, hindi makatao o nakakasakit ang pagtrato sa magsasaka o sa kanyang pamilya at alam ito ng may-ari ng lupa at hinahayaan lang, pwedeng tapusin ng magsasaka ang kasunduan. Pangalawa, sinasabi dito na kung ang may-ari ng lupa ay hindi tumutupad sa kanyang mga obligasyon na nakasaad sa batas o sa kanilang kasunduan sa magsasaka, may karapatan ng magsasaka na wakasan ang kasunduan. Pangatlo, pwedeng tapusin ng magsasaka ang kasunduan kung pinipilit ng may-ari ng lupa ang magsasaka o ang kanyang pamilya na gumawa ng trabaho na hindi naman related sa pagsasaka, lalo na kung hindi sila binabayaran nito. Pang-apat, kung ang may-ari ng lupa o ang kanyang kinakatawan ay nakagawa ng krimen laban sa magsasaka o sa kanyang pamilya, may karapatan ng magsasaka na wakasan ang kasunduan. Next, I'm going to discuss the rights of the agricultural leaser. But first, what is leaser? Leaser is simply the person or entity who owns a property and rents it out to someone else. Una, sinasabi dito na may karapatan ang may-ari ng lupa na suriin kung sinusunod ba ng magsasaka ang mga napagkasunduan sa kontrata at ang mga probisyon ng batas. Parang tinitignan lang nila kung nagagawa ba ng magsasaka ang kanyang responsibilidad. Pangalawa, sinasabi dito na pwede ang may-ari ng lupa na magmungkahi ng pagbabago sa kung paano gagamitin ang lupa o kung anong mga pananim ang itatanim. Pero, hindi ibig sabihin na basta-basta na lang nilang pwedeng baguhin ang kontrata. Dapat pag-usapan muna ito ng may-ari at ng magsasaka. Pangatlo, pwedeng i-require ng may-ari ng lupa sa magsasaka na gumamit ng mga napatunayang paraan ng pagsasaka na makakatulong sa pangangalaga ng lupa, pagkapabuti ng fertility nito, at pagpapataas ng produksyon. Pero, dapat isaalang-alang ang financial capacity ng magsasaka at kung may access siya sa credit facilities. Pang-apat, may karapatan ang may-ari ng lupa na i-mortgage o gamiting collateral ang inaasahang upa mula sa lupa. Ibig sabihin, pwede nilang gamitin ang kita sa lupa para makapag-loan.
Prohibitions to agricultural lease. Number 1 is to contract to work additional landholdings belonging to a different agricultural leaser or to acquire and personally cultivate an economic family-sized farm without the knowledge and consent of the agricultural leaser. It means the lease cannot work additional landholdings or cultivate a family-sized farm without the leaser consent. Number 2 is to employ a sublease on his landholding provided, however, that in case of illness or temporary incapacity, he may employ laborers whose service on his landholding shall be on his account. It means subleasing. The lease cannot employ a sublease except in cases of illness or temporary incapacity, where they may employ laborers at their own expenses.
Okay, so good day everyone. My name is ENRERAS RAULENE, and now let us proceed to the prohibitions on agricultural lessors. Okay, so let's talk about what a landowner can't do when they have an agricultural tenant. Basically, the law puts some restrictions on them to protect the farmers. First off, a landowner can't just kick a farmer off the land whenever they feel like it. They have to get permission from the court first. There's a specific process they need to follow under Section 36. If they try to evict a farmer without that court order, they can be held liable for damages suffered by the farmer, and they might even face fines or imprisonment. Another thing, the landowner can't make the farmer pay their taxes. Paying taxes on the land is the landowner's responsibility, not the farmer's. Also, the landowner can pass on any of their own financial obligations to the farmer. If the landowner owes someone else money for the land, they can't force the farmer to pay that debt. If the crops need to be processed before being sold, like
If it's sugar that needs to be refined, the landowner can't make deals with buyers without getting the farmer's go ahead. The farmer needs to be part of those negotiations. And finally, this is a big one. The landowner can't mess with the farmer's right to organize. They can't discourage them from forming or joining a union, and they can't try to control or interfere with any farmers' organizations. Next, we have the cost of irrigation system. It states that the agricultural lessor or the landowner exclusively bears the cost of constructing a permanent irrigation system, including distributor canals. However, if the irrigation system leads to a proportional increase in the tenant's yield or the agricultural lessee, the lessor is entitled to a corresponding increase in rental fees. If the lessee refuses to bear the increased rental cost, they are not entitled to compensation for the irrigation system upon termination of the lease, nor is the system considered an improvement under the provision of this section. Next, we have manner, time, and place of rental payment. The consideration for the lease of the land shall be paid in an amount certain in money or in produce, or both, payable at the place agreed upon by the parties immediately after threshing or processing, if the consideration is in kind, or within a reasonable time thereafter, if not in kind. So the statement explicitly prohibits the agricultural lessor from requiring the lessee to file a bond, make a deposit, or provide a preferential lien in their favor for rental payments beyond the gross harvest necessary to cover the rental due. Next is exemption from leasehold of other kinds of lands. So, this section addresses specific land types, including fish ponds, salt belts, and lands primarily planted with citrus, coconuts, cacao, coffee, durian, and other similar permanent trees. The tenancy prevailing on these lands is governed by the provision of Republic Act No. 1199 as amended, indicating a separate legal framework for these specialized agricultural lands. Then we have possessions of land holding exceptions. The agricultural lessee retains the right to possess the land holding even after an agreement on surrender or a future surrender date, until a court judgment authorizes their dispositions after due hearing. This protection is contingent upon the lessee demonstrating that: Number 1. The agricultural lessor owner or a member of his immediate family will personally cultivate the land holding or will convert the land holding, if suitably located, into residential, factory, hospital, or school site or other useful non-agricultural purposes. Next, the agricultural lessee failed to substantially comply with any of the terms and conditions of the contract or any of the provisions of this code unless his failure is caused by fortuitous event or force majeure. Then the last is, the agricultural lessee planted crops or used the land holding for a purpose other than what had been previously agreed upon.
Good morning, everyone. I'm SHEILA ENERO, and I'm going to discuss some of the rights of the farmer. First is right to self-organization. Farm workers have the right to form or join groups or associations of their own choice to protect their right. They can talk to farm owners about work conditions or negotiate for better pays and benefits. Right to engage in concerted activities. So farm workers can work together in groups to protect their interests. They can take part in peaceful activities like meetings or discussions to demand for better treatment or solve work problems. Third is right to minimum wage. Farm workers must receive at least minimum daily pay at least 3.50 a day or 203 pesos a day per 8 hours of works as stated in the law. Even if there's an agreement or contract that says otherwise, farm workers cannot be paid less than the set minimum wage. Fourth is right to 8 hours of work. So a farm workers should only work up to 8 hours a day. Employers cannot force workers to work beyond 8 hours daily. If they do, it should come up with extra pay or overtime pay. Right of action for damages. So if a farm worker gets injured or dies while working, the employer is responsible for compensation. The employer must provide help or pay damages just like in other workplaces. Right to compensation for personal injuries that are illness. This means that if a farm worker gets injured, sick, or dies while working their job, they or their family have the right to receive compensation or financial help from the employer. The employer must help pay for medical bills or give financial support to the worker's family. Right against suspension or layoff. Farm owners or farm managers cannot fire, suspend, or lay off a farm worker without a valid reason, especially if the worker or their groups has filed a complaint or petition about working condition or treatment. They cannot remove or punish a worker just because they stood up for the right or reported unfair treatment. Distribution of agricultural lands of the public domain. This rule talks about how public agricultural land or government-owned farmland can be given or distributed to farmers. So, the President of the Philippines can set aside this land and it will be surveyed, titled, and transferred to the land bank. Then, the land will be divided into smaller lots and be given to the individual farmlands. The government can divide and give the public farmlands to farmers, helping them have their own land to work on. Next is agricultural land. Agricultural land is any piece of land used for growing plants or crops. It includes rice fields, farmlands, salt beads, fish ponds, idle lands, and even abandoned plants, as long as they can be used for farming or growing something. Next is agricultural lease and agricultural lessor. Agricultural lease, these are farmers who works on the land. They planted and grow crops on the land that belongs with someone else with permission. Agricultural lessor, these are the landowners who allows farmers to use the land. Agricultural year, it is the period of time needed to grow and harvest crops. It starts from preparing the land, planting seeds, caring for the crops, and harvesting. In short, it is the full cycle from planting to harvesting. Last is final provisions. If someone breaks the rules stated in certain sections of the agricultural law, Section 13, 27, and part of Section 31, they can be punished. A punishment may be a fine up to 1,000 pesos or 1 year of imprisonment, or both depending on the decision of the court.
So I'm EUNICE LAGUITAN. So the Agricultural Tenancy Act had several serious flaws that made it hard to succeed. First, many members of Congress were rich landowners, so they did not support the law. They did not pass another law to provide money or funds for its implementation. Because of this, the program could not be properly carried out even if it looked good on paper. Second, the law only applied to rice and corn lands. This was unfair because other important crops like sugarcane, coconut, and others were not included. As a result, landowners could easily escape the law by planting different crops instead of rice or corn. Lastly, there were no punishment or penalties for landowners who tried to avoid the law. Some landowners would pretend to change the land's use or transfer ownership to their relatives. These tricks were commonly ways to cheat the system and stop land reform from helping the farmers.